Now, the reason they had that declaration was recognized by international treaty law in order to establish the new legal crown entity of the Incorporated United States Middle Templar King George III agreed to in the Treaty of Paris. Quote, between the Crown of Great Britain and said United States. Well, wait a minute. The Crown of Great Britain is the same as the Crown of the United States. So there's the agreement right there that is totally a total fraud.
Okay. Mm-hmm.
So, most important is the actual signatories of the Treaty of Paris. Like I said, they were all esquires. So, this legally signifies officers of the King's Court, which are now known as Templar Courts or Crown Courts. So this is the same Crown Templar title given to Alexander Hamilton. So, David Hartley, he was a Middle Templar of the King's Court, representing the United States. John Adams, Ben Franklin, and John Jay. They were all the signatories for the United States, and were also Middle Templars of the Crown's Court through the Bar Association. Plainly written in history, proves again that Crown Temple was representing both parties to the agreement. Perfect and elaborate scam, huh? How are the American people ever going to know this? They don't. They don't go into research like we do and find out. They have no idea this is sitting in the background controlling them.
Now when you mentioned Patrick Henry's opposition to such.
Right.
Was there a sizable number of people involved in government in that day?
Oh yeah, yeah. There was. If you get stories, Anti-Federalist. It's called the Anti-Federalist, and it's edited by Herbert Storing, and it's a really good book. It's a complete Anti-Federalist book, and Pennsylvania, Massachusetts, Maryland, Virginia, and New York are all represented in here. It also gives the speeches of Patrick Henry in the Virginia State Ratifying Convention. That's 1788. And they have, numerous. Agrippa is one of them from Massachusetts. They wrote. Another one was the minority of the convention. They all called themselves different names at the time. Then there's the essays. There is the Pennsylvanian. And what happened in one of the Pennsylvanians, and also the letters called the Federal Farmer, there was a big hullabaloo because they said Pennsylvania couldn't get down to the convention, and they already passed everything without them being there. So, in the Pennsylvania, called the Minority Convention, it says, I'm quoting right out of Storing's, the Congress might gloss over this conduct by construing every purpose for which the state legislatures now lay taxes to be for the general welfare, and therefore as of their jurisdiction. And the supremacy laws of the United States is established by Article 6. And it goes on and talks about it and says, as there are no articles of taxation reserved to the state governments, Congress may monopolize every source of revenue and thus indirectly demolish the state governments. Well, they've done that now. For without funds, they could not exist. The taxes, duties, and excises imposed by Congress may be so high as to render it impracticable to levy further sums on the same articles. But whether this should be the case or not, if the state government should presume to impose taxes, duties on the same articles with Congress, the latter may abrogate and repeal the laws whereby they are imposed upon the allegation. Now, those people knew at the time, and they were coming in and saying all this happy stuff was going to happen, and it was not right. But the average American people, just like the average American people today, they could care less. They weren't involved. They didn't want to get involved. They just wanted to make their life and go on and get what they could and have all their worldly possessions that they had. And, they weren't worried about how government men who was taking over and ruling their lives, to infinity.
Now, this this happened under Jefferson's watch. Is that true?
No, this was under Washington.
Washington, okay.
Yeah.
But
yeah, because this was October 12th, 1787.
Okay, right. And Jefferson wouldn't come around until the turn of the century.
Yeah.
All right.
And it said in their thing, he's saying, "Dear Sir," and he goes in and says, "It is to be observed that when the people shall adopt the proposed Constitution, it will be their last and supreme act. It will be adopted not by the people of New Hampshire, Massachusetts, etc., but by the people of the United States." See, right there, they're telling you that they knew that the people, the common man in the states, had nothing to do with the Constitution creation, ratification, or whatever, and it was never ratified anyway.
There's a Marxist, and despite the fact that he is such, wrote a book called Toward an American Revolution.
Uh-huh.
And his name is Freisa, F-R-E-I-S-A. And you know, he had some points which I had to take into consideration, despite the fact that he thinks maybe Marxism is the answer. But you know, he called it an elitist document. Would you agree with those terms?
He called the what?
He called the Constitution an elitist document.
Yeah, that's what it was.
Right.
It was created by the elite people who were the signers. The people didn't sign it. It was only those people who had money, and they had the power, and they actually owned land in Europe, Great Britain, France.
Well, could you comment then, though, on the Bill of Rights? I mean, I think that is exceptional. How does that fit in with the whole idea of their
The Bill of Rights, all right, the Bill of Rights was strictly for the United States. It was strictly for those people and not the common inhabitants, of which there was 207 inhabitants in the area called the United States, or Washington, D.C., what it is now. In other words, if you go and read the John Barron case, you will see that the Chief Justice comes right out and says that the Bill of Rights was not made for the people of the states, because those states had their own Bill of Rights, and it was only for the United States. And that's all the way up to the present year 2000 when I studied it, and I found a book on constitutional law that goes through every case that was brought up, which was never been overturned, the John Barron case.
Well, when you say it's only for the United States, are you defining the United States as you did before?
Washington, D.C. That's it.
Okay.
The United States is actually Congress assembled.
Okay, so in other words, they granted themselves
yes
these rights.
They granted themselves that Bill of Rights, not the average common man on the street.
And so they just indemnified them against certain kind of, dictatorial powers and such, but the rest of the people, as you and I are,
right.
We swung in the wind.
Yeah, that's all.
And still do to this day.
Still are, yeah. That's why they say don't bring in the constitutional rights. When you bring in... See, what they did, how they brought in the Bill of Rights into the states is under the Due Process Clause of the 14th Amendment. That's how they started to bring it in. And the case, the book, probably have to go to the library and get it. It is the Cases in Constitutional Law, the 3rd edition, by Robert E. Cushman and Robert F. Cushman. It is Appleton Century Cross, and it'll give you all the cases in constitutional law. And I'll give you the Library of Congress card number is 68-18704. The last time it was copyrighted was 1967.
Okay.
And they have, in the John Barron case, I'll open that, I just happen to have it here. It said...
I tell you what, I mean, hold on a second for that. Right at that point, because I tell you, we haven't really done any business. I want to tell everybody, this is the Grassy Knoll. With us is the Informers. You can go to the website atgpress.com, and you'll find his writings. And let's talk about that now, because you do have certain publications for purchase, do you not?
Yes.
Okay, and I'm going to that right now. Now, just to clarify, you do have one volume of Which One Are You that is out of print?
Right.
And I think you've addressed this before, but I'll ask you to do it again. Everything else is available.
Yes.
Okay, and also, folks, he's asked very specifically about how to purchase such, and you had said that if anybody just puts in a notation on the money order or inside a letter that you heard this on a radio show, that you would, give them 10% off the total?
Right.
Okay. All right. Anything else that you want to alert people to that you have under your name on that site?
No, that's about it. The other site is just right after mine, is James Montgomery,
right.
And that will go a lot more into the Crown, and because he is doing a lot of the research in that, and I let him do that, and I just kept on going on the taxes and the rest of the history and putting it together. But Montgomery is an excellent researcher on that. In fact, I emailed you something over.
Yes.
The other day on that.
If you do go to the homepage of atgpress.com, which stands for Against the Grain, you can read his works. If you click on the link stated as Knowledge is Freedom, which is the upper one on the right-hand column. And I don't want to put you on the spot, but just off the top of your head, do you know whether James has in the past or is willing perhaps to do some interviews?
I don't know. He was over here, and as I said, he was a truck driver, and he's been put off of the road because he's got high sugar, and they can't drive with high sugar.
I see. Ooh.
So right now, until he gets the sugar under control, he's sitting home, and that's the reason why he came up for a visit. And I briefly mentioned to him about the radio show, and as long as he's home, I think maybe he just might.
All right, excellent. And I would ask you to broker that if you could, and I'll
Sure.
follow up on your directions. Thank you very much for doing that.
Okay.
Now back to business. You were about to read to us.
Okay, the Barron versus Baltimore. That is 7 Peters, 243, 8 Lawyers Edition, 672. It's an 1833 case. All right. Chief Justice John Marshall delivered the opinion of the court. Here's one of the things he said. The Constitution was ordained and established by the people of the United States for themselves, for their own government, and not for the government of the individual states. Each state established the Constitution for itself, and in that Constitution provided such limitations and restrictions on the powers of its particular government as its judgment dictated. The people of the United States framed such a government for the United States as they supposed best adapted to their situation and best calculated to promote their interests. Now that says a lot. And in here it said, it's worthy to remark, too, that these inhibitions generally restrain state legislation on subjects entrusted to the general government or in which the people of all the states feel an interest. Now, what they're talking about there is the ex post facto law and the 9th section, restriction on state regulation, which was no state shall, blah, 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 blah. That's the only other part. Now, when they come down, see, John Barron was in Maryland, and when the government did something in their wharf there, they created a situation where in paving the streets of Baltimore, diverted their streams and everything, and the sand and gravel was deposited near Barron's wharf. So he sued them out, and the decision in the Barron said has left an indelible impression on the development of civil rights. While today Barron would have brought his case under the Due Process Clause of the 14th Amendment, the process of change by which parts of the Bill of Rights have come to be applicable to the states has been slow, uncertain, and confusing. While most rights in the Bill of Rights now do apply to the states, they do so only because they are essential to due process of law. Therefore, when anybody comes in and institutes the Bill of Rights, you know what they say, don't bring that up in my court.
But do you find that, I wasn't paying attention, before 2000. But even since that time that I have been paying attention, it seems that these complaints come up more and more often. Now, is that just a flaw in my observation, or
no? It's been there. Well, I don't know if you say a flaw in your observation, but if you don't follow the cases like we do, you wouldn't know. And there's, I don't know how many cases that come back, and I have them on my computer, and I wrote an article, I think, on that, on the Constitutional. I don't know if it's on HEG Press or not, but I do have it. It's quite lengthy, and it goes through every case that I dug up on the John Barron, and you can shepherdize the John Barron case, and you can follow all the cases all the way up and go to the library and pull every one of them, and it's right there.
Okay.
And it just, every one of the cases says it has not been overturned to this day, and the last case I saw was the year 2000. So right there, when you look at the term United States, all it means is doing business as, or AKA, Congress. Because it says Congress assembled in the United States. And the same way as the President, when he's announced, he is announced the President of the United States. It's not the President of the United States of America. Because if that were to happen, he would have to okay every one of the 50 governors' legislation. He'd be the top man it would go through. But he's not. He is the President of the United States. You just look on TV whenever he's announced, not the President of the United States of America. He's the President of the United States.
But then what does that say about the relationship to the states then?
That says that the states, at one time, were supposedly, or this is what the myth is, independent. But they're not, because remember, the Crown Temple owns them all. Even the United States, even the Maryland and Virginia, which turned over part of their property or state to the Congress, was still all owned by the Crown Temple.
You know, I looked up that definition of state in Black's. You know, I had that 6th edition, which we talked about in that last show.
Oh, okay.
But you know what's interesting too, and this goes back to the notion of what a state was prior to the Civil War. And it describes it as being capable of entering into international relations with other communities of the globe.
Yeah. Now, why would that happen when a state was supposed to be forbidden in the United States Constitution to attack piracy on the high seas and all this other stuff, and that it couldn't create or start a war with a foreign country? Well, simply because they're all owned by the Crown Temple. So they can do whatever they want.
So in other words, in one sense, they were allowed to do commerce.
Right.
But they could not do, I guess, battle or...
Right. They couldn't declare a war against France. New York couldn't declare a war against France. It would have to be the United States declare the war against France. And Florida couldn't stop someone on the high seas for piracy. It would have to be the United States. The state only went out 3 miles, and the United States went out as far as the international boundaries would let them go.
All right, so the United States went from that 3-mile demarcation point to the international waters.
Right.
We don't even know about that today, though, do we?
Nope.
We don't even look at 3 miles belonging to a particular state, do we?
Nope.
Okay.
People have no idea.
Okay.
So, now, okay, let's get back to, when you read Article 5, it says, to provide for the restitution of all estates, rights, and properties which have been confiscated belonging to real British subjects, end quote. That means the Crown Colonies were granted to persons and corporations of the Crown Temple through letters, patent, and charters, and the North American colonial land was owned by the Crown. The catch-all is in Article 4. It is agreed that creditors on either side shall meet with no lawful impediment to the recovery of the full value of sterling money of all bona fide debts heretofore contracted. Okay, so that means that since the Crown and its Templars represented both the United States as debtors and the Crown as the creditors, then they became the creditor of the American people by owning all the debts of the former colonies, now called the legal crown states. Now, sounds too good to be true, but the word scam and hoodwink can't begin to describe what has taken place. So, what debts were owed by the Crown Temple and their banks? As of 1883, in the contract between the King and the 13 United States of North America signed in Versailles, July 16, 1782, in Article 1, here's what it states. It is agreed and certified that the sum advanced by His Majesty to the Congress of the United States under the title of a loan in the years 1778, 79, 80, 81, and the present 1782 amount to the sum of 18 million of livres, money of France, according to following 21 receipts of the above-mentioned underwritten Minister of Congress, given in virtue of his powers to wit. That's a quote. Now you know where the money is still owed. It's infinite. It will never drop off. That amount equals to $18 million plus interest that Hamilton's U.S. Central Bank owed the Crown through the Crown Bank loans of France. And this was signed, remember, by Benjamin Franklin, who was the Middle Templar of the Crown.
But that was a contract with France.
Yeah, there was a contract with France.
Yeah, because who else is that co-signed by? Do you remember who the French dignitary was?
No, I didn't get that. But an additional $6 million was loaned to the United States at 5% interest on February 25th, 1783. So the Crown bankers in the Netherlands and France were calling in their debt for payment by the future generations, us. And that's how it's been ever since. That's why you'll see in the IMF, you have a BMF code, Business Master File. We're all considered a business. And it's a docket code 300, and that is U.S. Treaty, Great Britain, money owed to it. It's right there.
All right, so you're saying to this day, and I guess in perpetuity, that we will be in servitude to actually the bankers, right?
Yeah, to the Crown.
To the Crown, but not only the Crown of Great Britain, as what you've just said. Are we looking now also at France and the Netherlands?
Oh yeah, because that becomes, if you look at the concession of England to the Pope, May 15th of 1215, that's when the charter of the fealty of the King John to the Pope Innocent and the Roman Church was witnessed before the Crown Templars, as King John stated when he sealed it. He says, quote, I myself bearing witness to the house of the Knights Templars. Mm-hmm. End quote. So,
and John was a sovereign of England.
Yeah. Yep. So the particular words that they use there, especially charter, fealty, demur, and concession, they're all really, that's why I say it's very important to know what the definitions of the words actually mean, not what they're presumed to mean or what you think they mean.
Or what they've
totally
come
different.
to mean, yeah.
Yes. Now, if you go and look in the Informer site under terms, not words, you'll find that if you pick up the Internal Revenue Code and you go back to the definitions, 7701A, every one of those definitions starts the term, da-da-da-da-da-da. Right there clues you in that it is not the word means this, it's the term means this. And term and word is so much different, like night and day, that you wouldn't believe it. Most people, they have no idea. They think a word is a term and term is a word. It's
well,
not.
Let me do this if you don't mind, for those who are listening right now, whether or not they're on your site. But real quick, how you have broken it down from Black's, I guess, 4th edition. The term is a word or phrase, an expression, particularly one which possesses a fixed or known meaning in some science, art, or profession. And then underneath that you have words. Symbols indicating idea and subject to contraction and expansion to meet the idea sought to be expressed. As used in law, this term generally signifies the technical terms and phrases appropriate to particular instruments or aptly fitted to the expression of a particular intention in legal instruments. And then it says, see the subtitles following. If you could capsulize that for us, can you give us an example even of what would be a term and what would be a word, even if it's the same word or term?
Okay. They have to say it's a term or a word in the statute, and that's where they do. So then you can take a word, which you'll find in the dictionary. You can go, let's say capitulate. You go to a Webster's dictionary or any other dictionary and you look up the word capitulate. That is the average meaning that the average person knows it to be. Now you take capitulate and you say the term capitulate, and then you define it. That means that you have now taken the standard dictionary, throw it away, and look at what the statute definition is. Just like when you go and look at the term United States in the Internal Revenue Code, and it will define it how they want it defined, and that's why they use term. That means that term is limiting. It cannot include anything else. That is why there's so much argument is the word includes and including, and everybody argues this and that and what it means. But if the word term is in there, you can say term limits the use of what they're defining, and therefore it does not include and cannot include other things within the meaning.
All right. As I'm looking at this, and now it's just hit me, when it ends, when that term definition ends, in your website it says, in some science, art, or profession. So now I'm thinking, as we all talk about how certain industries and businesses have their own lexicon.
Right.
So what they've done with term is, when you take a word, but then when you want to, let's say, have a designation specifically to what you're doing, whatever that should be, whether it's the laws, it says science, art, that's where it changes, isn't it?
Yes, that's where it changes.
All right, you're taking some kind of word, you're saying, okay, in this particular field, it has this designation. Okay.
Yeah. Just like when they say domestic and foreign in 7701A, I think it's 3 and 4. All right. Domestic means to the United States, where the law is written. Foreign means to the states out in the Union. And then when they say a corporation, it's a domestic corporation, just like Bruce Shaber. Okay, let's look at that case. I'm going to stop right here because I know we probably don't have much longer to go.
We only coming up on 3 minutes.
Okay. Bruce Shaber lived in Kings County. I have all the documents from Kings County, New York, and worked as a clerk, but that was to New York. That's foreign. So when he had stock in the Union Pacific Railroad, the United States owned it. That is a domestic corporation. He had stock in a domestic corporation, was a foreign entity, and had to pay the amount of money that the IRS said he had to pay because it was a domestic corporation and he was a foreign stockholder.